Good evening, friends. Today I am making this video in the biting cold of Ambala. This is my 75th video, and this will cover an issue where most of our bungalow owners and residents do not understand, and they generally tend to fight on a topic whether the Governor General orders passed by the Governor General and Council, do they have a statutory force of law? So this has to be discussed today. And I would discuss some of the acts and laws, how this actually came up. This all is related to the Governor General Order 179 of 12th September 1836. Now, will this be covered under the 1833 Act, or does it have the force till the Constitution or the Indian Repeal Act? What actually does the law interpret this? So we must understand, by the Pitt's Act of 1784, the Queen of England gave powers to the East Indies Company's officers to make laws and regulations for their factories and the area where they were operating, their operational jurisdiction areas. Finally, by 1790 or 1765 onwards, the British started taking the administrative regain of the Indian terrain. Well, starting from Bengal presidencies to begin with. So finally, we were given an act called the Government of India Act 1833. Now we must read the section 43 of this 1833 Act. It provides that the Governor General and Council shall have the power to make laws and regulations for repealing, amending, or altering any law and regulation, whatever now in force. Now he is speaking of two terms, laws and regulations. So we will now, in the coming videos of mine, will understand what is the law and what is the regulation. Similarly, the section 45 of the same Act 1833 speaks. It talks that all laws and regulations made as aforesaid, so long as they shall remain unrepealed, shall be the same force and effect within and throughout the said territories of an act, as an act of Parliament, ought to be within the same territories, and shall be taken notice by all courts of justice, whatsoever within the same territory. Now I am suffixing those, it is to be within that territory, within the same territories, the same manner as any public act of Parliament. So this act is called, regulations and laws are called Act of Parliament. Would and ought to be taken notice, and it shall not be necessary to register or publish in any court of justice any laws or regulations made by the said Governor General Council. So this law by 1833 had a lot of demeaning effects. Meaning hereby, does it stand up till the 1915 or between the 1858 Government of India Act and then finally the 1935 Government of India Act? Now we will we will straight jump to from 1858 or 1833 to a section of 130 of the 1915, which says the repeal. Any item which is in the fourth schedule are hereby repealed to the extent mentioned in the third column of that schedule. Now what does that third column speaks? Provided that this repeal shall not affect A, B, C. A means the validity of any law, charter, letter patent, order in council, warrant, proclamation, notification, rules, resolutions, orders, regulations, directions, or contracts made in any form prescribed in a set tabled manner under this enactment shall remain in commencement. The B part says it validates validity of any appointment or any grant or appropriation of money or property made under this enactment, hereby repealed, or the tenure of offices, conditions of services, pensions, terms of remunerations, it all stands. So what is this section 130 1915 actually speaking? In lieu to the Government of India Act 1833 and 1858, we need to understand this, which I will elaborate in my coming video. Now the laws which were made under the 1833 Government of India Act, will they continue to be a force by this section of 1858 of Government of India Act, section 65, which said all acts and provisions now and then in force shall remain. Now here we need to read the Government of India Act 1935 Schedule 4. Now what does that section 321 of the Government of India Act speaks? It says repealed the earlier Government of India Act 1915. So that means the act is repealed, Government of India. But it says in section 292, thereof saved the existing laws by proviso. So one side you repeal and the other side you save back. So nowhere the regulations made after 1833 were or could be repealed or cancelled in a very plain language to people, I would say. This is what the Britishers were trying to say till 1935. Now what does the British Statute under the Indian Repeal Act in 1960 speaks? Now it says in section 2 of this act, it provides the British Statute specified in the schedule insofar as they extended to and operate as part of the law of India or any part thereof are hereby repealed. Now what does this affect to the 1833 section 112? So the repeal of the remnant of the Government of India Act. Now it says what is repealed? What is the remnant part? Now we need to understand the word repealed. How does it matter to a general rule or a law? What is repeal? It simply says when a parent act is repealed, all laws made thereunder stand repealed. But it does not apply to laws made under a Constitution Act. Such a law has to be expressively repealed if it has to be effected. In the case of subordinate legislations, the emanating law dies unless it is saved. But a law made under the Constitution Act survives. Till what I just said, if it is not expressively. Now this is somewhere even said in the, if we read the Charter Act, it says, or the Journal Clauses Act, what is the retrospective effect or what is the Repeal Act. How do we understand this? What is repeal? And why cannot these Governor General orders be repealed? As per any Constitution Act, it stands on a higher footing than a law made by a legislative authority, created because of the Constitution given by the Pitt's Act of 1784. And a law which is created stands on a footing higher than that the law made under the authority of that law. So we need to understand what is the constitutional law speaking of and what is the legislative law speaks of. So we can repeal the Cantonment Act, but they say we cannot repeal the Governor General orders because they are driven from the Constitution. What effect and how are these laws to be repealed? Now I will simply read a quote of the repeal from a dictionary. The effect of a repeal is to dry up the source of power. Repeal of an enactment only means that the power to create new laws thereunder is abolished, and so no further law in exercise of that power can be made. Now, if the 1836 GGO, if people understand, it was amended thrice, so it was not repealed. If something is merged in exercise of the power, the source of which has been dried, it can continue to remain as an independent unit or with the parent act, depending on the nature of the source of the power. So again it is saying, where is the power coming to the Governor General to make laws and regulations? It is coming from the Constitution. So if that remains, so the law can still remain in power. If something is merged in exercise of the power of the source of which has been dried, it can continue to remain as an independent unit or with the parent act depending upon the nature of the source of the power. If the source of the power is a Constitution Act, the law survives as an independent unit now. But if the source is the legislative power, then the repeal undermines or diminishes the law ends. It is a dying law. So we need to understand, when we finally were given independence and we made an Act of Independence 1947, Section 18, what does that speak? 1, 2, 3 it has. I'll speak the third, which relates to the British Statutes. It says, save as otherwise expressively provided in this Act, the law of British India and of the several parts thereof existing, immediately before the appointment day shall, so far as applicable and with the necessary adaptation, continue as the law of each of the dominion and the several parts thereof, until otherwise provision is made by laws of the legislature of the dominion in question, or by any other legislature or other authority having power on that behalf. Now, when law is made under the Constitution, who has the power? It is the Parliament of India. Will not be the Bombay Parliament or the Bombay legislature or the Bengal legislature. So here we need to understand. Now we'll read the Constitution of India. Under Article 372, it says, the Constitution saved all existing laws, providing, 1, notwithstanding the repeal of this Constitution of the enactment referred to in Article 395, but subject to the other provisions of this Constitution, all the laws in force in the territory of India immediately before the commencement of this Constitution shall continue in force therein until altered or repealed or amended by a competent legislature or other competent authority. Now, do we understand who is the competent authority to repeal the GGO? So, the British Statutes, under the Repeal Act, only those statutes which were specified in the schedules have been repealed. Otherwise, by the Indian Act or the 1833, the 1933, very clearly section says that these Governor General orders have a statutory force of power. The effect of the repeal was the repeal of whatever had remained subsisting to the Government of India Act in 1833. See, we go back from Constitution to 1833. It was only Section 112 of the Act which had continued to remain a part of the statute, that alone can be deemed repealed by the British Statute. Application to India, Repeal Act 1960. It did not repeal the law. Why? Because it was born from the parent act and had obtained an independent existence of subsisting law because of the Constitution. So friends, if we read the preamble of the GGO 179, it very clearly speaks of by rescinding all various orders in force of regulation prior to the promulgation of this Governor General order. So I, in my coming video, will exhibitively explain you all these schedules which I mentioned of 1833, 1858, 1915 and 1935 Government of India Act, and then try to sum up whether the court, in interpreting that these statutory law GGOs are in force, or should they be standing repealed. Friends, once again I am ending this video by saying that we must say that we are old grants, because we were revenue free grants. We were paying nothing, never converted into new grants. We were grants of the 1765, 1790 or 1812, culminating to 1859. So please, my humble request, please join us on these YouTube channels, website. Get your neighbor along with me in the Zoom meetings which I am conducting. Thank you. Good night.